In this podcast, we'll talk about certainty of terms and the ways in which terms can become uncertain. The rule here is that a contract may fail to come into existence even though there's been an offer and acceptance because of an uncertainty as to what has been agreed. Another way of saying this is that the court cannot make a contract for the parties which they themselves did not make. If the contract is not clearly created by the parties' language or conduct, courts can't construe one. The existence of a contract is based upon each party accepting reciprocal obligations. This is premised on the assumption that it's possible to determine what those obligations are. Therefore, one of the requirements of a contract is that the courts must be able to define the parties' obligations with certainty. This goes back to the underlying principle of consensus ad idem. Are parties truly in agreement? Has there been a meeting of the minds? Do they share an unambiguous understanding of their respective rights and obligations? Recall, an acceptance of an offer to a contract that departs materially from the material terms is not effective. No contract arises. Parties have to agree to the same terms, and if not, then parties may have agreed to something, but it's not a contract. Now, how will these kinds of situations arise? Well, there will be the usual exchange associated with offer and acceptance. We will be presented with what appears to be a complete agreement, but the obligations that have been accepted will not actually be clear. So the problem is not that the parties have agreed to different things, but that it's not possible to determine from the words in the agreement what they've actually agreed to. Then the matter goes to court, and one of the parties will assert that an agreement exists and will argue the interpretation it intended the uncertain words to mean. The other party will usually say there is no agreement and the terms at issue are too uncertain from which to be able to derive any agreement. Quick note about the terminology. The cases will discuss whether the terms are enforceable or whether the contract is, quote, void for uncertainty. And this is misleading because it suggests that a contract exists but can't be enforced because the terms are uncertain. The point of this part of the unit is to determine whether a contract came into existence at all. Was a contract formed? If a contract exists and a party breaches by failing to perform, the law offers a remedy, but a remedy can only be granted if the contract exists. Just a recap on the elements of contract formation. We are now at number 4. The general rules. Parties must make their own agreements. Courts are not going to do it for them, meaning that if there's an agreement and the terms could mean any number of things, or there are vital terms missing, if the court puts in those vital terms or interprets the terms in one way over another for no particular reason, then the court would be making the agreement for the parties. Parties must express themselves in a way that the meaning of the agreement can be determined with a reasonable degree of certainty. Courts don't want to guess at what the parties wanted the contract to say. Courts will use an objective standard when looking at the agreements. We are not looking at what did the parties actually intend. We're looking at what must reasonably be viewed as having been reasonably intended, given the language used and the circumstances in which the agreement was concluded. The traditional contract view says that if parties fail to reach an agreement on all essential terms of the contract, or the parties express themselves in an unclear way so the court cannot determine what they intended, then the agreement will fail for certainty of terms. The reason is because parties will not have reached a sufficient consensus ad idem to enable the courts to enforce their agreement. The policy behind this is that the parties may have been thinking that the contract meant different things when they entered into it, and courts don't want to impute their reasoning. Now, as with the topic we just covered in the earlier podcast, this traditional view of contract law has to be balanced with the commercial realities. What are those realities? Well, the parties may have been unable to anticipate future events when drafting the contract. They didn't account for certain things. The parties may not have been advised by lawyers, so they may not have been aware of the essential terms to be stipulated. Parties may have assumed that the usual terms will apply, or they may have assumed they entered into a contract and went about performing. So if the courts later find there's no contract, the parties have already detrimentally relied on the agreement. And so we have to find a balance between the traditional contract principles and commercial realities. We have to find a balance requiring parties to reach a complete agreement. And in that balance, we are reluctant to defeat the expectations of parties that an enforceable agreement has been reached. So what is the result? Well, courts try to be flexible in trying to find agreements in order to fulfill the expectations of parties. There is, however, uncertainty as to when courts will exercise this flexibility or how they will do it. But we do know that they look at certain things, and we see these factors underlying a lot of the cases in this area. They look at detrimental reliance by the party seeking enforcement. Courts want to protect detrimental reliance. They look at the bad faith of the party seeking to avoid enforcement. So if there is bad faith, the courts are less willing to help the party. They look at the reasonable expectation of a concluded contract because courts want to protect reasonable expectations. How does uncertainty arise? It arises when terms are vague, when the contract is incomplete, when the agreement is one to negotiate, and when there's an anticipation of a formalized agreement. The rest of this podcast will be about vagueness. Usually, the problem with vagueness arises in agreements that are complete on their face, but one or more of the terms are ambiguously expressed. And the rule is that if an important term is vague or imprecise, such that a court cannot give meaning to the term, the agreement will fail for uncertainty. The reason for this is that the obligations of the parties are not defined, and so a contract cannot be formed. But the reality is that courts rarely fail to find an agreement based on vagueness. Courts try to find a contract if there's been reliance. They try to find meaning in parties' words. They will refuse to enforce if the meaning is impossible, but if a particular term in the agreement is incurably uncertain, it may be possible to sever that term and to have the rest of the agreement remain valid. So it doesn't necessarily mean the whole agreement is void for uncertainty. In the case of CAE Industries, there was an agreement to purchase the Winnipeg base of Air Canada by a private sector purchaser, and the plaintiff purchased the base on the basis of assurances. The base required 700,000 man-hours of direct labor per annum, and the government recognized the possibility of man-hour shortfall. The ministers told the plaintiff that the government could guarantee no more than 40 to 50,000 direct man-hours per year, but would commit itself to employ its best efforts to secure additional work required from other government departments and crown corporations in order to meet its goal. The defendant didn't provide the man-hours sufficient for the viability of the operation, and it went to court. And the issues were, did the parties intend to create legal relations? And was the contract void for uncertainty? And again, remember the misleading language that we talked about. The real issue is whether a contract has come into existence at all, not that a contract exists and then becomes voided. Now, why is intention to create legal relations an issue when contract certainty is an issue? Well, recall that intention to create legal relations, if it's a commercial contract, there's a presumption of an intention to create a contract. So the onus of proof is heavy on the person who asserts there is no contract, and the burden here was not discharged. There was an intention to create a contract here. As for certainty of terms, if the parties have expressed themselves in language sufficiently clear as to have created rights and obligations, courts should try to give those words effect, especially if the contract has been partly performed. Now, how do you look for this? Well, you look at the substance, not at the form of the words, which is the usual form and style. The courts have to make every effort to find an agreement, especially where the contract has been partly performed. Courts will struggle against the difficulty ensuing from the vagueness of the contract. The contract doesn't leave anything unsettled that needs to be settled. It is an entire contract. Now, there is a guarantee to set aside. What is this? It's a binding commitment guaranteeing the provision of set-aside work. The commitment must be construed in a reasonable fashion, which is an objective standard, in light of the language used. The language referred to assurances as commitment, and the guarantee provided 40,000 hours of set-aside work to be provided. And, quote, best efforts to secure additional work. Again, look at it in light of the contract, the parties, and its broad overall purpose. It created a broad obligation on the government to employ its best efforts to secure additional work from other departments. Overall, it means that nothing further had to be agreed upon. These same problems will arise in real estate transactions in which the purchaser's obligation to close is dependent on obtaining satisfactory financing for the transaction. So just like the best efforts clause, the word satisfactory can cause problems, and courts are not uniform in their resolution. Some courts refuse to enforce the provision on the basis that satisfactory is uncertain, but others have said that some objective measure can be introduced. It's also important here to keep in mind that contracts cannot account for every contingency. So just because an agreement may be difficult to interpret or not provide for every scenario does not mean that the agreement is uncertain for vagueness. I wanted to bring this excerpt to your attention because the court talks about differentiating between difficulty of interpretation and uncertainty. And the issue here was, is the order too vague? Finally, Ms. Kedmi says that the order issued is too vague and cannot be enforced. Why does she do this? Well, she says there are differences of interpretation between her and her husband about the agreement. Although she has a lifetime interest in the matrimonial home, she does not know what would happen if Mr. Coram becomes bankrupt or sells the property. She's not sure what she's responsible for repairing. She's not sure what happens if the house is rented during her extended absence. And the court says none of these items render the agreement vague or unenforceable. It is important not to confuse lack of certainty with difficulty of interpretation. No agreement can provide for every possible eventuality, nor can an agreement preclude differences of opinion about its meaning or enforcement. But these difficulties do not render agreements vague or unenforceable. They are all matters that parties can either negotiate or have resolved by resort to the court. It may be true that there are additional terms that Ms. Kedmi would like to have included in the settlement, but their absence does not vitiate an agreement that was intended to be binding. Also important to note, if you hold a clause is incurably uncertain, it doesn't mean that the entire agreement hasn't come into existence. So if it's possible to sever the term in issue and have the agreement be valid, the court will opt for that option.